Right now, I'm pleased to welcome the Attorney General of the great state of Ohio, David Yost. Hi, David. How are you?
Fantastic, Hugh. It's good to see you.
You know, General, Jim Tressel got named Lieutenant Governor today, and I'm kind of still stunned by that news, but do you think he's going to make the punt the official play of the Ohio football program?
I think he's going to be a great LG. He's a good friend and a wise man.
I know. Someone asked me, is he running for governor? I said, I think he's 72. I don't think he really wants to run for governor. General Yost, I got the amicus brief that the state of Ohio filed on its behalf and the behalf of 19 other states in a case called Catholic Charities Bureau, Inc. versus Wisconsin Labor and Industry. And I've read it, and you're right. Would you explain to laymen what Wisconsin Supreme Court did with regard to Wisconsin Labor and Industry Review Commission and Catholic Charities?
Sure. So, Catholic Charities applied for a routine charitable tax exemption and was denied. The It went up through the courts, and the Wisconsin Supreme Court basically said, "Yeah, you do charitable stuff. You feed the poor, you house the homeless. You do good stuff, but lots of people do that, and they're not churches. You're not entitled to that kind of religious exemption, that charitable exemption. You're not doing anything different than the government does, for that matter." And so they defined charity out of the mission of the Catholic Church after 2,000 years of unstinting charity work in all corners of the globe. It's an affront to the First Amendment. It's a misapplication of precedent. And most importantly, it's dangerous to American freedom, because if you give the government the ability to decide this is church stuff, but that's not church stuff, that way lies totalitarianism.
Now, General Yost, the Wisconsin case has been accepted by the Supreme Court, and I think it tees up the reversal of Employment Division v. Smith. You certainly argued that in your brief, that Employment Division v. Smith does not work. Are you happy, or are you mixed feelings about the fact that Wisconsin stepped in it this way?
Well, one of my goals when I became Attorney General was to see several badly decided 20th century cases overruled, among them Chevron and Roe. We've seen those. Smith is on my list, and Wickard v. Filburn is the last. Those are the last holdouts. So maybe this is going to be a win-win here.
Justice Barrett said, and by the way, did any of the justices recuse themselves from this case for any reason?
Not that I know of.
And because she did not participate in another religious grant of cert in a free exercise case involving Oklahoma's charter school program and the application of a homeschooling Catholic charter school to receive funds, and she did not participate in the grant of cert. I don't know if she's participating in the case. I hope so, because in a previous free exercise case, she said, without deciding, we got to get around to Smith. And this tees it up, because tell people what Wisconsin doesn't want Catholic Charities to do anymore, or at least not receive a deduction for doing it.
Basic charity work. So we're not talking about holding mass. We're talking about feeding people that are hungry. We're talking about ministering to the mentally ill, providing home shelter to the unsheltered, and they participate in a lot of other things, including foster care, as a private partner of a public funder. This is a common arrangement all the way around the country. We've got faith-based organizations that are delivering social services, and they're generally protected in the exercise of their religious freedom from government intrusion into the state, which, if there is a wall of separation between church and state, it's not in the Constitution, but if that exists, the wall is there to protect the church from the meddling of the government.
When I read the description of the 4 subdivisions of Catholic Charities that the Wisconsin Employment Division, whatever they are, didn't want to have a tax-exempt status, it's like Goodwill Industries. it's just indistinguishable from secular charities doing the same thing about which no one says anything.
Right. It certainly appears that Wisconsin Supreme Court and their taxation authorities maybe have a little bit of an animus toward religious or faith-based institutions, doesn't it?
Now, how did you get the other states to let you lead on this? Because everyone would want to lead on this case, David Yost.
Well, we saw the case get granted cert, and my SG and I immediately got on the phone with our colleagues and said, we'd like to do this. Fortunately, Ohio has a wonderful SG shop, Elliot Geiser, who you've had on your program,
Yep.
well respected around the country, a former clerk for Justice Alito. And our colleagues were very pleased to have Ohio leading on this.
Now, how long did it take to produce the amicus brief? I'm not sure what the briefing schedule is, but the cert was just granted in December, I believe.
Yeah, it took us a few weeks to get it written and tweaked up. I'm a little proud of this actually, because one of the arguments is an argument that I drafted personally, which cites the famous case of McCullough versus Maryland.
Oh, yes.
And
the opportunity to tax is the opportunity to destroy. I'm teaching that tomorrow, and I saw that. The opportunity to find religion is the opportunity to destroy religion.
The power to regulate is inherently destructive. So I'm hopeful that the Supreme Court is going to issue a clear overruling of Smith, set down a very clean test that is going to restore some coherence to the jurisprudence in this area.
I want to close here, Attorney General Yost. Where can people, by the way, find this for themselves if they want to read the brief, which is a really fine intro to free exercise and related fields? Where can they find the brief?
Thank you. It's on our website. It's also on the Supreme Court website.
Okay. So if you have your druthers, do they end up saying the Establishment Clause is not implicated here by the grant of status as a charity, as a religious charity to the subdivision of the Catholic Charity? And, oh, by the way, you cannot burden the free exercise of people who believe their religious faith requires good works.
My ideal hope is that they say the government may not decide whether religious activity is bona fide or not, that it's a strict scrutiny review, and that almost always any government attempt to exclude something that a church is doing is going to be off limits unless there's a compelling governmental reason, purpose behind it, and it's very narrowly tailored. Neither of those tests are met in this case.
That's strict scrutiny, and I'm glad you said that, because there's a case, Tony and Susan Alamo Foundation out there, where it was a cult operating basically on slave wages, and the Social Security wasn't getting their due, and the court stopped that. You're not arguing to overturn that. You're just arguing for a rule of reason that has to survive strict scrutiny, and this won't if applied, correct?
That's absolutely right. Of course, churches are subject to the law like everyone else. The rule of law means the same rules for everybody. But just like any other fundamental primary freedom, it has to meet that strict scrutiny standard in order to survive a constitutional challenge. Wisconsin's action here doesn't even get close.
It doesn't. This should be easy. This should be 9-0. It won't be for a variety of reasons, but I hope they get rid of Smith, and congratulations for leading the charge on this, Attorney General David Yost from the great state of Ohio, once again leading the way in all things important, except the Super Bowl. But we'll get there. We'll get there. Someday we'll get there.